Public lewdness, what is it? Can you defeat your charges of public lewdness? Hi, I'm Jeff Hampton with the Hampton Law Firm. Welcome to our YouTube channel. Today I want to talk to you about a crime that people don't really talk about much and you don't see it as often. It's called the crime of public lewdness. Now, if you wait around to the end of this video, I'm also going to provide you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Now, let's talk about this for a second. What is the crime of public lewdness? Now, basically, Texas criminal law tries to penalize certain type of sexual behavior, and they classify it as a criminal act, even if the actions were taking place between consenting adults. And so you got to understand that when we look at this crime, many people look at it and say, it's not that big of a deal. Who cares? It's just two people having sexual activity somewhere. Well, the problem with it is this is most commonly seen as the crime that is sex in public, right? Or some type of sexual activity that's taking place in public. And so if you are convicted for this type of offense, it is a big deal because here's the problem. If you don't handle this case properly, particularly if you are a first-time offender, having a conviction on your record, people look at a case like this and they think, whoa, hold on a second. Is there some type of sexual deviancy going on here? Does this person have a problem? And that can affect your ability to get gainful employment. It can affect just your reputation in the community. All right. Now, what constitutes public lewdness in Texas? Now, as I've told you already, most people refer to this crime as the sex in public law. That's kind of what they think of it as being. But let's see what the actual law says. Texas Penal Code section 21.07 requires the state of Texas through the prosecutor's office to prove the following elements beyond a reasonable doubt. A person commits the criminal offense of public lewdness if he knowingly engages in any of the following acts in a public place, or if not in a public place, he is reckless about whether another is present who will be offended or alarmed by the act. Okay, now let's talk about what this is. The acts are, number one, an act of sexual intercourse. Number two, an act of deviate sexual intercourse, an act of sexual contact, or an act involving contact between basically whether it's mouth to genitals, anything like that. Look, everybody knows what sex is. Everybody knows what that is. I could try to walk you through it all, but you know what I'm talking about when we talk about this here. So there are a number of factual scenarios where someone may be arrested for this type of offense, but the reality of it is it's penalizing. The spirit of the law is attempting to penalize sexual behavior at a location that creates a high risk that someone else might see you, thereby resulting in the alleged victim being offended or alarmed by the sexual behavior. For example, sexual activity during a movie in a movie theater. That's a pretty obvious one, right? So if there's sex going on in a movie theater, young couples engaged in sexual activity in the backseat of their car, or young couples engaged in sexual activity in, say, a public park or in a place where the public has access. So if you're going to defend this type of situation, the first thing you have to do is to identify what is the definition of public place. What does that mean when the law says public place, when you're looking at a public lewdness charge? Well, here, let me give you the definition. Public place under Texas law is defined as, quote, any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. For example, we represented a client one time charged with public lewdness for engaging in sexual activity with his girlfriend in his car that was parked in an apartment complex parking lot. Okay. Now, when he hired us, he wanted us to know is, hey, listen, that was not a public place. I mean, it says public, but this was a closed-off facility. It was a private apartment complex. People had to have gate access in order to get in there, surrounded by fences. And so one of the things we had to make sure our client understood was you have to first identify whether it's a public place, not on what our opinion is of whether it was public, but what does the law say is public or not. And so a public place it is defined as a place where a substantial group of the public. Well, what would that be? In this situation, the apartment complex residents, that's a substantial group of the public, they have access to in that common area, which is the parking lot. The car they were in during the sexual activity was located in an area that a substantial group of the public had access to. Now, we had other defenses for that particular client, but that was one of the areas that was brought up. The next question is, what does reckless mean? What does it mean for public lewdness in Texas? We defined that there was a requirement of even if it's not in a public place, you can't be reckless about where you were having the activity. Well, in order to be convicted of this crime, the state of Texas is going to have to prove that you engaged in sexual activity that was reckless about whether another person who was present would be offended. And so here is the definition of recklessness under Texas criminal law. Recklessness is defined as disregarding a substantial and unjustifiable risk that the result will occur. In plain language, recklessness means you recognize there was a substantial risk of your behavior when you were doing the behavior, but you decided to ignore it and do it anyway. For example, having sex with someone in the bed of a truck, surrounded by other parked cars, which we've seen a situation like this, would be behavior that a reasonable person would likely believe there is a high probability someone would see what's going on and be offended by that, okay? Now, let's talk for a few moments about legal defenses, okay? We've identified the public place element, the recklessness element, and let's talk about that in more detail because it's critical that you hire an attorney that's willing to explain your possible defenses that are available to you and craft a particular defense strategy that will help put you in the best place possible to get your public lewdness charge dismissed, all right? Now, what if the sexual activity was not in a public place? Well, if the activity was not performed in a public place, it will make a stronger defense for your criminal defense lawyer, all right? Legal of the state of Texas can still prove the crime of public lewdness if they can show beyond a reasonable doubt that you were reckless about whether another person would be present that would be alarmed or offended. Now, I'm going to give you an example because the only way that you can really work with these is to kind of give you some examples of situations. We represented a client charged with public lewdness because she was having sex with they were having sex together, boyfriend and girlfriend, in a tent on a parcel of public land in a park, okay? Now, this is different. Let's talk about this for a second because the activity was taking place late at night. No one else was camping in the area at the time. And during the sexual activity, what happened was someone else pulled up, got out to walk out by the lake, observed them in their tent doing what they were doing, and called the police. Of course, the police show up and claim, hey, what are you doing out here? This is on public land. You were being reckless about the activity that you were doing. But the question is, was this really reckless behavior? Was it reckless? Would a reasonable person believe there was a substantial risk that someone else would see the sexual activity in this example? Well, our argument to the prosecutor was absolutely not. They were not being reckless because there was no one else nearby. At the time this activity was taking place, there was no one else camping near them, and a reasonable person would not believe anyone else would be present to observe. Now, look, if they weren't in the tent and they were having sexual activity out in plain view, that's different. Right? But that's not the situation that was taking place here. Why am I bringing this up? This is the type of detailed analysis and fact-by-fact observations that have to take place with a good criminal defense attorney to point out these weaknesses in negotiating you a good result. Okay? Now, let's look at legal defense number 2. What if sexual activity did not take place at all? What if there was no sex taking place? Listen, what exactly did the witness claim to see? In order for the case to be proven beyond a reasonable doubt, they got to have a witness. And if the prosecutor calls a witness, that witness is going to have to get up there and say, I saw them having some type of sexual activity, and that activity has to meet the definition of the penal code we just discussed. So are they able to testify that they actually observed the sexual activity? Or did they just assume that sexual activity was going on? Failure by the state and their witness to prove these elements will result in a not guilty verdict at a jury trial, or perhaps a dismissal of your criminal charges. For example, we represented a client that had been arrested for a public lewdness charge for alleged sexual activity that was taking place with his girlfriend in the car. The witness spoke to the police officer and began to talk about how that she knew that they were having sex, she saw them, we know for sure that's what was going on. But as the criminal case was set for trial, further questioning of that witness determined that she wasn't exactly 100% sure what she saw. She just jumped to conclusions. And I mean, during cross-examination, some of the questions were like, well, hold on a second. So whenever you observed them, how close did you get? Well, and what exactly did you see? And some of her responses were, well, I don't know, the windows were kind of foggy. Is it possible they were just kissing? Well, it's possible. Well, if it's possible they were just kissing, that's not sexual activity as defined under the Penal Code. Okay, that is not going to end up constituting public lewdness. And so she just jumped to conclusions and assumed that there was sexual activity that was taking place. And so engaging in the actual sexual activity is a critical element of the crime. And if they can't prove there was sex going on, there's no crime. Okay? Now, what are the consequences for a conviction for public lewdness? Well, under the Texas Penal Code, public lewdness is classified as a Class A misdemeanor, punishable by up to 1 year in the county jail and up to a $4,000 fine. And so here's the thing. There's several ways this can be done. We've already identified in terms of getting your case dismissed. The first is to just negotiate the fact that the case should be dismissed for a lack of evidence. If the prosecutor can't meet their burden, sometimes we can convince them to just dump the case straight out of the gate. And that's what you should be looking for when you talk to your potential criminal defense attorney when you're looking to retain a lawyer. But a second option can be sometimes when the prosecutor is doubting kind of where they're at and what they're willing to do when you're negotiating, you might be able to establish reasonable doubt and obtain the leverage to get what's called a conditional dismissal. Sometimes the prosecutor will agree to dismiss the case in exchange for community service hours being completed, maybe a donation to a charity, maybe a class being performed. And in exchange for that, you still get the benefit of having your case dismissed and being eligible for an expunction. All right. Finally, you always have the right to a jury trial. You always have the right to be able to take your case in front of a jury and obtain a not guilty verdict, because that jury, because this is a misdemeanor, would have to have 6 jurors all in agreement, unanimously in belief that you were guilty and that the elements of the crime had been proven beyond a reasonable doubt. Now listen, maybe you or a loved one are facing a public lewdness charge in the North Texas area. If so, I want to offer you a free consultation and a free case analysis. Don't hesitate to contact the Hampton Law Firm. I'd be happy to speak to you, answer any questions that you have, and I promised you if you waited around to the end of this video, I would also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All you have to do is click the link below, and I'll be happy to email that over to you directly. And I want to thank you for joining us on our YouTube channel today. If you enjoyed and if this helped you in some way, share this video, like it, subscribe to our YouTube channel. We'll be happy to send you more great content just like this. Thanks again for joining us. We'll see you next time.